Today, we'll break down the legal aspects of preimplantation genetic testing to ensure you stay compliant and informed. Let's start with the legal foundation. Under the Assisted Reproductive Technology Regulation Act 2021, PGT is strictly regulated. Section 25, subsection 7 of the Act explicitly mandates that PGT can only be used to screen for severe genetic conditions, chromosomal abnormalities, or sex-linked genetic diseases. Clinics and laboratories offering PGT must comply with RT Rules 2022. Here's what this means in practice. PGT must only be performed for known genetic risks. The focus should be on conditions carrying a high risk of severe genetic disorders. Any misuse of PGT for non-medical reasons, such as sex selection, is strictly prohibited. Licensing and accreditation are critical compliance steps for clinics and laboratories conducting PGT. IVF clinics must obtain specific certification from the State Board under Rule 15, subsection 3b of the ART Rules, 2022. Genetic testing laboratories must be NABL accredited and registered with the appropriate authority. Annual compliance reports documenting all PGT procedures must be meticulously maintained to avoid penalties. Informed consent is not just a formality, it's a legal necessity. PGT-specific consent forms must include comprehensive genetic counseling documentation. Written informed consent must cover the scope and limitations of the testing procedure, and must include the potential for false positives and negatives. Written consent also includes the criteria for embryo selection and disposition of affected embryos. There must be separate consent for incidental findings. Additionally, as per recent updates, video recordings of counseling sessions are mandatory, and a 72-hour cooling-off period must be observed between counseling and signing the consent form. Failing to adhere to these standards can result in serious liability. The most crucial liability is the liability of standard of care. Doctors must offer PGT in cases with documented genetic risks only. A collaboration with certified genetic counselors is non-negotiable and mandatory. The next most important liability is the documentation requirements. There has to be detailed family history records. Also document the test selection rationale and laboratory protocols. Maintaining records of the results interpretation and patient communication logs is also mandatory. Managing risk in PGT requires a robust system at every stage. In the pre-testing phase, develop a protocol for verification of medical necessity, patient education, and insurance coverage. In the testing phase, ensure quality control measures, chain of custody documentation, and contingency plans for emergencies. And finally, in the post-testing phase, maintain communication protocols, do follow-up counseling, and ensure data protection. In 2024, the National Guidelines for Genetic Testing and Services introduced significant changes which include enhanced privacy protections for genetic data, standardized reporting formats, and mandatory periodic audits. Also, digital consent documentation is now allowed, provided it meets statutory requirements. Remember, patients now have the right to withdraw their consent until embryo transfer, which must be clearly communicated. As technology evolves, so do the legal challenges. PGT is a powerful tool, but navigating its legal framework is equally important. If you found this video helpful, please like, share, and subscribe to my channel for more medico-legal insights on IVF.